I'm Greg Remke. I work with economic thinking. We do workshops on the economics of high school and homeschool speech and debate topics. The Stoa League has three proposals out, motions for the coming school year to be voted on, and one of these is on labor law, calling for substantial reform of one or more of the laws administered by the Department of Labor. So I've got some notes on this online on our economic thinking website. It was considered last year. There's a lot of ongoing debate. Labor unions and government agencies worry that companies are going to exploit workers. So state and federal labor laws are there with the intention of protecting people as well as providing job training and other benefits. These are sort of shared between federal and state governments. So any of these could be reformed under this resolution. One of the concerns that's in the news now is skepticism over the gig economy, the economy that has Uber and Lyft drivers being independent contractors, DoorDash drivers, others who are working for online companies who can choose when they work, but are also guided by the policies of the company. So labor unions want to unionize these workers. State and federal regulators want to regulate them. They say, well, gosh, if you're an employee, you're better off because you get benefits and you're more secure and so forth. Gig economy workers like to have the independence to choose when they have to work, but also they'd like higher wages. So you get a lot of disagreement about what would be best. One of the interesting things, because the federal government hasn't acted on this, state governments have. The state of California passed a labor law that mandated that gig economy workers working more than a certain number of hours had to be treated as employees, so would qualify for minimum wages and benefits and so forth. However, there's a pushback from Uber and Lyft who say that would disrupt their services they provide. Here's Vox magazine saying it's a win for workers everywhere. This is, the standard progressive view that all you need to do is pass a law to get higher wages and more benefits. However, in the Los Angeles Times, after the passage of AB 5, Vox Media itself, that publishes Vox, just cut the jobs of hundreds of their freelance journalists in California. They were working as gig economy workers writing articles for Vox, I think particularly for one of the sports publications they have. And then in response to this labor law, they were let go. So this is happening through the state's nurses and others who are independent contractors are fighting this. Truck drivers were stuck. A federal judge has done an injunction on that. So yeah, because all the truck drivers that are working as independent contractors, all of a sudden they can't do trucking in California because they're not employees of the various companies they provide services for. So a federal judge has stepped in to block that. This is just one example, sort of in the news now in the U.S. and Europe over labor regulations versus reality as in sort of the innovative online economy. Interestingly, unions used to be support organizations for what were essentially gig economy workers. You'd go to the bricklayers union hall, and you'd wait. And when some contractor needed a bricklayer, instead of having his own employees do this, he'd bring somebody out from the union who was certified to be capable at bricklaying, and then that guy would work for the day and get paid. Unions have shifted in many ways, and so the union battles against administrations and conservatives and liberals and so forth has shifted. Unions are monopolies now. There aren't six auto workers unions like there are six auto makers. Instead, there's just a handful of major unions that dominate their industries, and that's related to labor law. So unions and federal regulations that protect, they've protected union power for a long time, and that led to the expansion of unions. But critics of the Reagan administration and later Republicans now say that federal regulations have weakened unions. Unions, again, are a big part of labor law, but they're not a big part of the U.S. economy anymore. They used to be a dominant force in manufacturing. Now they're not. A tiny percentage of workers are in unions in the private sector, although a large number of government workers are union employees. And this is part of the pushback in that, closed shop and open shop, various debates about what rights workers have. Do they have to join a union to take a government job and so forth? So that's been debated. The Freedom Foundation in Olympia, Washington has been at the forefront of this. Okay, so lots to review in this topic. It's complex. I'm just giving a brief overview of some of the ideas, and I'll have some articles with more information. So one related thing, my earlier talk was on prison reform or penal reform, but I also had some discussion of legal issues. So in the case of, let's say, the state of California passes this gig economy law that means truck drivers have to be employees, a judge steps in and said, no, they don't. He basically blocked the law. Now, that might be considered judicial activism in the sense that if you want to change, if you don't like the law, then the legislature can change the law. So should judges defer to the legislature, or should judges engage to protect the constitutional rights of workers, the right to earn a living? So one issue with the Federal Department of Labor, what limitations does it place on the freedom of contract between people that want to work and people that want to hire them? So this is the Institute of Justice looks at judicial engagement, and they look at many, and these are mostly state issues where states passed regulations that you can't braid hair unless you've got a permit. You can't, open a restaurant or a stand selling food, a lemonade stand. You have to get a city permit. Should the Federal Department of Labor enforce or protect people's right to start a company and operate a company when state and local regulations restrict that? That's one of the issues to consider. And there's a video here I'm going to skip. So some of the books, this is about a liberty of contract. Example, a federal minimum wage law. The big push is to increase minimum wages. California sets it at $15 an hour. The federal government is much less. The push has been made mostly by the Democrats in Congress to raise the minimum wage to a living wage so that a family could, husband or wife could work and raise kids on the minimum wage. Critics of that saying that pushes people with less job skills out of the market because they don't have the income earning ability, at least starting off, to make a minimum wage. But beyond that whole question, I mean, again, should we raise it and how much is sort of the major question. But should there be a federal minimum wage law, right? If I want to hire debaters to work for me to do research and I'm willing to pay $5 an hour, if debaters are over a certain age and want to do that, should they be able to? Or, am I breaking the law and get thrown in jail by making a contract with people to work for less than the minimum wage? So there's lots of jobs and internships that are low pay that people gain job experience for, but our federal labor laws ban any of that unless it meets certain standards in regard to minimum wages. So that's an ongoing debate whether it should be higher, stay the same, or be eliminated entirely. And this part of the ongoing battle here is to what extent the legislature or what extent the Supreme Court should defer to the legislature. Right? A lot of the laws that were originally passed, regulatory laws, were specifically designed to stop African Americans from running businesses. And this was in the Jim Crow era in the South. And they were passed by sort of white supremacist legislatures in the name of public safety. And so that was considered, the Supreme Court said, well, we'll defer to you. You know best about safety. But in fact, the actual laws were restrictions on African Americans. Supreme Court Justice Clarence Thomas has mentioned that one of the challenges, I think, for his grandfather, who was in the business delivering oil for home heating oil, his biggest challenge is every year he had to go to the sheriff to get a permit, to get his permit renewed. The sheriff was white, his grandfather was black, and this meant that people in political power had power over minorities, over who could be in business. And this seems to be a violation of the Constitution, but when it's phrased in terms of public health, public safety, helping gig economy, whatever, you're letting legislators decide who can sign a contract and make an agreement. So is that protecting people from themselves, from exploitation? But that's part of the labor law debate. Cato Institute has, as well as the Heritage Foundation and American Enterprise Institute, have whole sections on labor law and regulation, arguing for simplifying and streamlining these things, that many are obsolete, many are counterproductive. And think tanks on the left, progressive institutions and think tanks, call for more stringent labor regulation to protect workers from corporations. So you have this debate through labor law that will be part of this topic. So there's the Cato Institute page. And we've done, I put together some, when we had a debate topic on federal court, the federal court system, we had overviews of these articles, Liberty of Contract and Overruled, and these are on our economic thinking page. So when we talk about regulations, labor regulations, environmental regulations, the argument is that these things add up. Now, the Obama administration and the Trump administration have tried to simplify federal regulations on labor, and particularly to reduce regulations of professions. And we'll come to that. But this is an annual publication of the Competitive Enterprise Institute called 10,000 Commandments. And it's trying to look at a snapshot of the federal regulatory state each year, which includes labor regulations and the Department of Labor. And when you add these up, they're significant. Now, I'm drawing from the 2015 report in this study, but something like $2 trillion annually in economic, environmental, occupational safety, and tax compliance regulations. Now, these are above and beyond those regulations that would, protect the environment, protect workers, and run the tax system. These are a measure, and it's, you can debate how they calculated this, but this is a measure by economists of what the cost of these regulations are. So this was the National Association of Manufacturers with Crane and Crane that did this survey, $2 trillion annually. Again, part of this is right in the labor law, which is occupational safety. 92 billion is part of that, and there's other areas where that is. In the chart here is of the number of pages of federal regulations, and again, just part of these are labor laws. But the argument is that had these excess regulations not been passed, the country would be a lot more prosperous than it is now. Everyday families would be wealthier. We would still have protection of the environment, protection of workers, and so forth, but these excess regulations could be eliminated. Some were obsolete, some were a bad idea in the first place. So this is more on that, some $39 trillion in excess regulation. This video that's linked here looks at regulatory capture and the argument that regulatory agencies tend to be captured by the industries that they regulate, which is why the regulations tend to be counterproductive. And we have, again, some posts on economic thinking on these issues, on reforming labor law from when this has been a topic in the past. So if you look at the U.S. Department of Labor history page, they explain that this came out of the progressive era. This was an era where reformers felt there should be much more federal regulation. And that era is still with us with agencies like the Department of Labor. So here's from the website, part 6 is progressive ideas. And so the view of the progressives was that job safety and health was too important to be left to employers. Employers couldn't protect workers. They needed state and federal regulations. So here's the Secretary of Commerce and Labor at the time saying the great enemy of this country is waste. It takes government to establish rules of the game to assure fair play for workers and others who cannot protect themselves. The Progressive Party declared the supreme duty of the nation is the protection of human resources. And so now here's a key part of it. One of the part of this progressive agenda was that you couldn't just rely on legislation. Part of setting up these federal regulatory agencies like the Department of Labor was to let them sort of make their own legislation. So labor departments and industrial commissions could independently issue new guidelines and new regulations without having legislation. So what we've got in the federal regulatory agencies are those that sort of they have a general guideline legislation, but then they add their new regulations, they enforce them, and they provide judicial review of them. So this sort of breaks the separation of powers that's integral to the U.S. government. So you could argue in many ways to decrease administrative rulemaking by the Department of Labor, or at least make sure that any rules that have a cost have cost benefit analysis, and if their cost is too high, that should be reviewed by Congress. That, whoever in the Department of Labor, they're not elected by the people. Why should they have the power to pass new regulations independently? Okay, thank you for listening, and if you have questions, please let me know. Thanks.